Hello friends, in the series on the income tax cases, today we will discuss the case of SWAL Limited versus Union of India and others. This case has been reported in 450 ITR at page number 148. The matter has been decided by Calcutta High Court against the order of a writ petition. This was basically an intra-court appeal. In this case, the notice under section 148A clause B was issued to the assessee and some information was seeked from the assessee. The assessee asked various documents like the statements of the persons on whom basis my case has been is going to be reopened, the copy of the approval for sending the notice under section 148A clause B, but in spite of repeated requests, there was no whisper from the part of the department whether they are going to provide these documents or not. The court said that whenever the assessee requests for some documents, then there are two options available to the assessing officer. First is that provide all those documents to the assessee on which the department is relying. If you are not going to provide these documents, then tell the assessee the reason why you are not going to provide these documents. And the court also said that you cannot take the plea that this information is related to the third party, that's why we cannot give you the documents. If you are using those documents for preparing the information which is attached as an annexure to the section 148A clause B, then you have to provide this information and these documents to the assessee. And one more thing in this case was that the assessee was saying that please provide me the opportunity of cross-examination of the persons on the basis of which you are going to reopen my case. Provide the opportunity to cross-examine those persons on the basis of whose statements you are going to reopen my case. But in spite of all these requests from the assessee, there was no communication from the department, and the case of the assessee was picked for scrutiny under section 148 by passing the order under section 148A clause D. So in this case, the court said that what the department is trying to do under section 148A clause B show cause notice, that it is trying to grab the information from the assessee. The court said that this exercise should be done prior to issuing the notice under section 148A clause B, because there is a section 148A subclause A in which the legislature says that if the assessing officer thinks that it has to collect the information, then he has to collect the information into those sections. But that part comes prior to issuing the show cause notice to the assessee under section 148A clause B. What the department is trying to achieve, that the department is trying to collect the information from the assessee itself under section 148A clause B. That is not the intent of the law. If you want to collect the information, then prior to issue of the notice under section 148A clause B, you collect the information and then you tell the assessee that this is the amount on which you are escaping income, and provide all the relevant statements, documents on the basis of which you are relying to the assessee, and provide the assessee the opportunity of being heard. Friends, there was a celebrated case of JK and Drive Shaft which was assisting the assessee in getting all this information from the assessing officer, but they were not providing the information on for one or the other reason. That is why section 148A was introduced. But now the section 148A is being misused by the department in a very open manner. Neither they are following the JK and Drive Shaft, neither they are following the guidelines which are there in section 148A, due to which there is a lot of confusion between the assessees. And in many cases, there are examples when the department issues the show cause notice under section 148A clause B to give the reply up to a certain date. But even before that date, they are issuing the notice under section 148. So what is happening is very pathetic, and this should be taken care of by the CBDT or by the courts, that these things should not happen, because the assessee is bearing a lot. Even going to the courts is not a right solution to the assessee, because the courts are also remanding the matter back to the assessing authorities. So it is creating a lot of confusion, a lot of hard work, a lot of pain for the assessee in getting into the writs and then again going back to the assessee for getting this information. So if the department cannot provide the information, then they have no right in issuing the notices in this manner. At the end of this video, once again, I am repeating the name of the case. The name of the case is SWAL Limited versus Union of India and others, and this case has been reported in 450 ITR at page number 148. Thank you, friends.